She opened her paycheck and $387 was missing. No warning, no letter, no phone call, just a number that did not add up. She called her employer, and her employer said 4 words that ruined her week. We received a garnishment. In the last video, we walked through how an old credit card debt ends up in a courtroom. Today, we are going to the part that actually changes your daily life. What they can legally take from you once they win that judgment, the clock you did not know was running, and the 3 non-negotiables if you ever get served. Welcome back to Sense and Simplicity. If you are new here, I spent over 20 years in banking as a branch manager and a district manager. Same disclosure as the last video. Once an account got past 180 days, the legal process was handled by teams I never worked with. Everything in this video is sourced to the U.S. Department of Labor, the Consumer Financial Protection Bureau, the Federal Trade Commission, and Pew Charitable Trusts research. All sources are listed in the description below, so you can verify every claim yourself. If you missed part 1 of this breakdown, watch that one first. Link is right above. Same disclosure as always. This is general information based on research, not legal advice for your situation. If you're facing a lawsuit, garnishment, or any specific legal matter, talk to a consumer law attorney or your local legal aid office. Let us talk about wage garnishment, because this is the one that destroys budgets overnight. When a creditor wins a judgment against you for a consumer debt like a credit card, federal law limits how much of your paycheck they can take. That limit comes from the Consumer Credit Protection Act, Title III, enforced by the Department of Labor. The number you will hear most often is 25%. That is a real number, but it is not the whole story. The actual federal limit is more protective than that, and some states protect you even more. Here is the actual math. Under federal law, a creditor with a judgment can garnish the lesser of 2 amounts. Option 1, 25% of your disposable earnings. That means what is left after taxes, Social Security, and Medicare. Option 2, the amount by which your weekly disposable pay exceeds 30 times the federal minimum wage. The federal minimum wage is $7.25 an hour. 30 times, that is $217.50 a week. Whichever of those 2 numbers is smaller is the maximum they can take. And if your weekly disposable earnings are at or below $217.50, your wages cannot be garnished at all under federal law. That is the floor, but some states go further. 4 states, Texas, Pennsylvania, North Carolina, and South Carolina, prohibit most consumer debt wage garnishment entirely. If you live in one of those states and a judgment is entered against you for a credit card debt, the creditor generally cannot touch your paycheck. The catch: your bank account is still fair game even in those 4 states. That brings us to bank levies. This is often the first thing people find out about because it hits without warning. A creditor with a judgment can go to your bank with a court order and legally freeze the funds in your account. Depending on your state, they can take everything up to the judgment amount all at once. Most people find out the first time their debit card gets declined at a checkout. Some funds are protected from bank levies by federal law. Social Security deposits, supplemental security income, veterans benefits, and certain federal retirement payments are generally exempt. But here is the catch: banks do not automatically protect those funds. You usually have to identify them and file the right paperwork with the court to claim the exemption. If you do not, the bank may just turn the money over to the creditor. This is another place where showing up and knowing your rights matters more than most people realize. I remember another customer, a single mother who worked at a manufacturing plant in our area. She walked up to the teller window one afternoon, not upset yet, just confused. Her direct deposit had come through short by almost $400. She was sure it was a payroll mistake. The teller pulled up her account on the screen. It was not a mistake. The money had been legally withheld by her employer and sent to the court to satisfy a judgment she did not even know had been entered against her. The lawsuit paperwork had been served months earlier, but to an address she had moved out of over a year before. She never received a single notice. She never had a chance to show up in court or to argue the amount. By the time she found out, the default judgment had been entered, the garnishment order had been issued, and the withholding from her paycheck had already started. She cried at the teller window. There was nothing the branch could do for her in that moment. She had to hire an attorney to try to vacate the judgment and get the garnishment stopped. Now let us talk about the clock. Every state has something called a statute of limitations on debt. It is the legal deadline for how long a creditor has to sue you on a credit card debt. Typically, it ranges from 3 to 6 years. A handful of states go up to 10. Once that deadline passes, the debt is what is called time-barred. A collector cannot legally win a lawsuit against you on a time-barred debt, but it does not delete the debt. It does not remove it from your credit report automatically. And the Consumer Financial Protection Bureau has been very clear on one specific point. If a collector sues you on a time-barred debt and you do not show up to court, the court can still enter a default judgment against you, even though the lawsuit itself was illegal under federal law. Time-barred is only a defense if you show up to court and raise it. Silence hands them the win every single time. Here is the trap the Federal Trade Commission has been warning about for years. In many states, if you make even a small payment on an old debt, or if you acknowledge in writing that you owe it, the clock on the statute of limitations resets. The whole period starts over. Collectors know this. They buy old debt for almost nothing, often the same 2 to 5 cents on the dollar we talked about in the last video. Then call people and try to get them to send in just $10 or $20. Anything, because that one partial payment can legally revive a debt that was already past the deadline. This is called zombie debt. If you get a call about an old debt you had forgotten about, do not confirm it, do not promise to pay anything, and do not send any money without first finding out whether it is time-barred. Ask for a debt validation letter in writing. Federal law gives you 30 days from the collector's first written contact to dispute the debt and demand that validation. So what do you actually do if you get served with a lawsuit? Here are the 3 non-negotiables, straight from Federal Trade Commission and Consumer Financial Protection Bureau guidance. 1. Do not ignore it, ever. Ignoring a summons is the single worst thing you can do at this stage. 2. File a written answer with the court by the deadline on the summons. It is called an answer, and it forces the company suing you to actually prove their case in court. 3. Seriously consider talking to a consumer law attorney before that deadline hits. Pew Charitable Trusts' research on this is clear. Consumers with legal representation in debt cases are far more likely to win or reach a settlement than those without. One Utah study found that 53% of represented consumers won their cases, compared to just 19% of those without a lawyer. That gap is enormous. Legal aid organizations are free if your income qualifies. Many states also have volunteer lawyer programs specifically for consumer debt cases. The Consumer Financial Protection Bureau website has free sample letters you can send to collectors, free templates for responding to common debt collection lawsuits, and a directory of state legal aid offices. All of those resources cost nothing. If you missed part 1 of this breakdown, sued for a credit card debt, here's exactly what happens next. The link is in the description and on the card above. It covers what leads up to everything in today's video. Your action step this week. If you know any old debt exists in your name, anything you have stopped paying on, find out the date of your last payment on that account today. Write it down. Save it somewhere safe. If you ever get a call or a letter about that debt, that date is the single most important piece of information you have. I know these last 2 videos have been heavy. They were meant to be. But here is what I want you to hear before you close this out. Even at this stage, even with a judgment, even with garnishment, even with collectors calling, there are still real options. Settlements, pay for delete, negotiating what collectors will actually accept, and, for some people, the bankruptcy question. That is where this series goes next. Subscribe so you do not miss it. And remember, the system works fastest against the people who say nothing. Do not be that person.